So together with Ian Laird, we thought that for this panel, we couldn't have a better moderator than Dr. Sabbagh. Dr. Sabbagh is a partner at Curtis Mallet here in Washington, D.C. And his experience includes serving as counsel and expert in international arbitrations commenced under various investment treaties, NAFTA Chapter 2, Energy Charter Treaty, the CT, and under major arbitral rules, including ICC, ICSID, UNCITRAL, and many others. In recent years, he has been particularly involved in matters involving the laws of a number of jurisdictions around the world, and the list is extensive. And I can say that from the list that I can see here, it might involve almost every continent. He has dealt with disputes involving a range of industries, especially renewable energy, mining, construction, royalty and licensing agreements, corruption, taxations, logistics, etc. But most importantly, I would say he really is an expert, and he has drafted and published one of the leading texts on damages and investment arbitration. He has extensively researched issues such as the Shorso factory case, and he also has an SJD, a doctorate from Georgetown, and I happen to be luckily a friend of his because we were colleagues at that time when we were doing the doctorate together. Borzu, the floor is yours.
Thank you very much, Jose, for the generous introduction, and welcome everyone. I'm very pleased to be here in the company of a great group. I mean, the topic that the organizers have assigned to us is how to draft the damages section of the memorial, and it is a practice session. So from the get-go, we decided not to have any PowerPoint presentations. Rather than that, we're going to kind of ask a set of questions to our very distinguished panelists and about how to do the job. And as you note that we have very distinguished group, we picked 2 lawyers and 2 valuation experts for this task because the damages phase of the case is the phase that we play some lawyer. I'm a lawyer, but we all know that valuation experts are the stars when it comes down to that phase of the case. So without further ado, let me introduce our panelists. To my left, I have Ian Laird. He's a co-chair of International Dispute Resolution Group of Crowell and Moring in Washington. He has served as counsel and arbitrator in investment arbitration since 1998. He's adjunct professor at Georgetown and co-director of Investment Law Center of the ILI. To my right, I have Julie Carey. She's a managing director at Nero Economic Consulting and energy economist who frequently provides expert evidence in energy and transportation related international arbitrations and other dispute venues. She has more than 25 years of experience addressing economic issues in oil and gas, power and renewables, pipelines, and railroad sectors. Julie frequently conducts economic analyses on energy markets, energy contract, and damages and valuation analysis. In addition to her expert consulting work, Julie is an adjunct professor at Georgetown University, where she teaches an energy economics and policy to graduate students in applied economics and political economy programs. I should take that course too. I didn't know that. And we have Courtney Hikava of Sydney, Austin. Thank you for hosting us. She focuses her practice on international dispute settlement with an emphasis on investor-state arbitration. She represents both cross-border investors as well as represent governments in proceedings before ICSID on the additional facility under UNCITRAL and other rules. She has experience in arbitration under bids, government contracts, free trade agreements, such as NAFTA and DR-CAFTA. She has represented clients in commercial arbitration, such as under the auspices of SCC, the Stockholm Chamber. And last but not least, we have Manuel Vasconcelos. He's a principal in the DC office of Cornerstone Research. He has a PhD in finance and is a CFA charter holder. His practice spans a number of different areas with a focus on market manipulation, trading analysis, and valuation. He has extensive experience in financial modeling and in the valuation of companies across a range of industries, and has consulted on a large number of US federal, state, and arbitration matters. So here we have our panelists, and let me start from the beginning. And I start by a question to our lawyer. Maybe I start with Ian. I guess let me put it like this. Ian, you want to start the case, preparing a request for arbitration, or you're writing a memorial. Step number one, you have a section on damages. How much space you're going to spend on it? Or you're going to kind of set out your position and tell the world what you're seeking, or you're going to be kind of sure a little bit of it? And what's the way to go about that?
Well, sorry to act like a lawyer here, but the answer to that is depends, of course. Yeah, I mean, I think the first thing to say is that damages are a critical issue, one that you need to deal with early and engage with your experts as early as possible. Sometimes that's a hard exercise because clients sometimes feel that they know their own economic situation, and they kind of have a feel for what the impacts have been with regard to, whatever it is, the contract breach or the contract or the treaty breach or whatever. They feel they know their business, but it takes a little bit of work, and I think it's worthwhile for counsel to have that discussion about why bringing in the economic experts, the valuation experts early, is that they bring in a different perspective. They generally have experience. They before testifying before tribunals and writing these types of reports, and they bring something extra to the table. And I think starting early is always kind of my preferred avenue. It's not always perfect, and it does not always occur in every situation. But as a matter of course, that's a good starting point, I think.
So you bring them early, and any comments on that, Courtney? Do you have a similar approach to kind of approaching the expert? And what is your reaction to the idea of, from a strategy, how to start the case with the drafting? Because they have asked us to particularly kind of comment on drafting the section of a memorial on damages. And I want to we're taking a step back a little bit, and I want you to see, do you agree with Ian? Do you want to expand on it a little bit?
I agree 100% with you.
Mm-hmm.
I would say my answer also depends, because I'm a lawyer, on whether you're representing the claimant or respondent. And so in writing the request for arbitration, we're representing the claimant. So and in that respect, I agree with Ian that we want to start very early, before even writing the request for arbitration, have a damages expert engaged, and so that we can present in the request what the big number for what we're claiming, or at least a range of what we're claiming, of what the damage is.
Mm-hmm.
And then if we're representing respondent, we also want to start early, but we can't really start earlier than when we receive the memorial, when we have the other experts report.
So are you suggesting, both of you, that you may, for example, in the memorial, don't give the full number, and why? What would be the strategy behind that, against it or for it? Can you a little bit kind of enlighten us about, because I have seen memorials when the claimants submit, and there is almost sometimes we reserve our right to kind of quantify it later. And then some of them, they come with some number. Later on, the next submission comes, the number is much bigger.
And in one instant in my entire career, I saw that the number is much smaller, but pretty much is always much bigger. That's how it progresses.
Yeah, I mean, I can see from the respondent's perspective, if the number actually gets bigger over the course of the arbitration, that would be somewhat irritating, although it does happen in the sense that you start with a memorial, and I think it should be the best number that the evidence supports. But that being said, as you go through another round of submissions and into the period before a hearing, new evidence can arise, new events can occur, adjustments can be made, and I think that's not a strange occurrence. I guess part of underlying your question is, when do you actually reveal your whole damages case? And I would hope that there's a good faith effort to provide, and maybe I'll put my arbitrator's hat on here to actually present the full case as early as possible. In terms of, if you have that evidence and you have that analysis and there's a reasonable basis to make that case, then, that is the kind of fair thing to do. That being said, and I guess this goes to your counter position that, say, if it's a notice document, would you expect a full and detailed valuation at that point? And I think unlikely, even though from a respondent's perspective, you'd like to get as much information as early as possible. That's just not how the process works.
But it's both of you essentially would like to get the evaluation expert involved as early as possible. That's the preference. Obviously, we have all sorts of budgetary restrictions, etc. We want to manage, but that's the preference on side of the council. Let me now turn to our quantum experts and ask perhaps Julie, what is kind of your approach to event? For example, let's say Ian has a big case and says, I need a top-notch expert, and he comes to you. Says, what would you like to know when kind of to be able to effectively help him and start kind of getting engaged and running and asking for documents and materials?
Well, the short answer is as much as possible and as quickly as possible. I'm focusing on it as not an advocate, as an independent expert that really is trying to get a lay of the land. So I want a detailed understanding of the parties, their business, what they relationships are, and sort of what's brought them to the circumstance they have, sort of recreating the fact pattern, if you will, at least at a high level, to put more of the pieces of the puzzle together of the nature of the dispute. And in terms of color and specifics, the economics, the financial implications, what the nature of the agreements and in the business case which arose to the dispute, to get some context of that. And in my specialized industries of energy and transport, I'm going to want to understand enough of the details of the specifics because it matters. You can have wide-ranging disputes. It's like our earlier panel was talking about solar cases with different outcomes. Well, I can think of a myriad of economic reasons off the bat that you would get, even with the same solar plant, different outcomes. So where's the location and what's the technology and all these other details. So I'm going to want to understand as much as I can about the industry and the nature of the economics underlying it, so that I can figure out as an independent expert, one, am I fit? Do I see myself as being able to act as an independent expert? And for example, with providing expert testimony decades in the past, I'm going to think through my work in the past and whether or not it's consistent. What the lawyers want as advocates is consistent with my economic opinions that I've given over the course of my career. And I'm also going to think about it, if I'm not the best fit, then who might be the best fit, and how else to be helpful so that important clients can get the benefits of my thinking for them to take on board and consider moving forward with their case.
Thank you for that comprehensive answer. Manuel, any reaction, anything that you want to add on this point or other issues that were discussed, like how early you would like to get engaged?
As early as possible. Okay. But I'd like to go back to Ian's point on the cost considerations, right? That usually it's you always think, well, if I hire them earlier on, I'm going to spend more money because there's more time to spend the money. That's not so linear, in my view. There are a number of factors that actually, in my opinion, would support retaining your expert earlier on. Or even if not retaining the expert, that's just having a conversation with the expert, having a conversation with the consulting team. First of all, we always try to do our best job, but if you're rushed, there's 2 weeks to put together a report. You won't have a lot of time to consider each approach carefully, and before you actually execute it, you'll just sort of go into execution mode right away, which might end up that you go with certain approaches of a menu of approaches that turn out not to be the most helpful ones or most insightful ones, and you end up dropping those, right? Had you had the time, maybe you'd have thought of that more carefully in advance, you'd have explored more background research, and then you could kind of select the path that most sense and ultimately would be more cost effective. The other reason is, it's not like you engage the expert in a consulting company and you just go off and start working, full time on this case for 6 months, right? I mean, you can just have a couple of conversations, getting some input into, for example, the numbers you're thinking about, putting into the different documents, whether there's some certain level of economic support for that, so you don't have to revisit those later on. I think just that initial conversation, if not very extensive, I think they're helpful.
Thank you. Let me turn now to our counsel again and ask, I think Julie to some extent explained what she expects to get from the counsel. And now my question to you is, what would you share with your expert, or what would you not share with your expert to begin with? And this is, you can pick on minutes.
Sure. I can start. We would share as much as, certainly all of the data that they need for their analysis as much as we can. And that's actually harder than it seems sometimes because of all of the administrative problems, with clients. But that's always the first push, is to get all of the data that underlies at least their analysis, or if they're responding to the other experts' analysis. And we always have creative ways of trying to get them these mass amounts of data that usually are difficult. And you can't be loaded online, or you have to do a hard drive. So that actually it's difficult, and it takes a while getting all that information. But as for things that we wouldn't necessarily share with them, things that would not taint their analysis, but that they don't need to know, for example, about some of the arguments, maybe legal arguments on the other side, that just would distract them from their purpose. So really the damages focus of the case that we share everything.
Yeah, no, that's perfect. You want to keep your experts focused on their task, and usually they have a pretty good idea of what they want from us to do that task, and I like to have that kind of interaction with them. And I think to Courtney's point, they don't need everything, because usually you have a lot of material which relates to issues that don't really go to quantum, and frankly, paying your experts to review all sorts of documents which they're actually not going to need to consider is not really cost effective for them, or effective, from a time management for them as well. So I think there is a level of not providing everything under the sun, but I think it's very reasonable and rational to take that approach.
So you want to keep them focused. If you give them legal documents, you just kind of tell them, pay attention to this or that. That is stuff that really goes into valuation rather than kind of determining other aspects. Any reaction by our experts to these? That, and maybe a related question are there issues that they ask you and say, you know what, I can't opine on this, that's the.
So, I mean, I guess what I would say first is, I think it's perfectly reasonable to try to have some guardrails, if you will, of the amount of information you want to give an expert. I tend to want to have dialogues about that so that I can understand from your perspective of what doesn't apply, to make sure that I'm looking at and considering everything that I believe is relevant. So the more communication around those available documents and what I may see as potentially relevant, I want to make sure we're talking. So more communication can sort through and make it efficient, but also allow me as an expert to say, I wasn't not given information that I really should have considered in developing my expert opinion. That will be my concern as an expert, and communications can be the balance in the middle, if you will. And then for your next question about what I can't opine on, yes, there are plenty of things I can't apply on. As an economist, valuation, damages, and also regulatory experience, I can testify to economic and financial and energy market aspects, but I'm not a lawyer. And I'm not going to give a legal opinion, and sometimes that can be intertwined or close to some of the economic opinions, about price terms and contracts and agreements amongst that may coexist in a legal document, if you will, but they're economic terms. And same too with regulation. So finding that aspect and making sure it's not legal. And then I would say, other technical aspects. So I'm not an engineer. I'm not working in energy and transport. You've got a lot of technical people who've operated facilities and otherwise have technical skill sets. That's not me. If cases have such needs for different expertise, you're using them as part of the team. I may want certain inputs from another technical expert, so they're working together, but I'm not giving a technical opinion.
But thank you for that. In a way, some of these issues, even a contract, some of the terms, maybe for example, fully legal, or some of them are kind of unclear. I'm sure you have been in a situation where counsel for a party puts a contract in front of you, ask, give me your views as an economist. What is your understanding of this provision? I guess those are the situations that you have to somehow deal with it at some point. But you raised another actually issue that I meant to raise earlier, and that is, I think this is a good time to jump to it, is that it's not only financial or economic experts that we need to do these cases. We need other types of experts. And at some point during the case, you reach to the conclusion that, maybe, I can't do my analysis on this thing. I need some expert, I don't know, you're a price expert. You say, tell me what's the price so I can put it in my formula. How do you approach that if you're looking at an energy transaction? Let's say you want to run a kind of a discounted cash flow under a long-term contract for an oil project. And obviously the price of oil is an important input. And would you do it, or do you have expertise to do the price, or you want to get someone else to do that?
So, I mean, everything depends on the case itself. And this issue comes up at the beginning of the case, right? So when I'm evaluating a case, I'm going to figure out what am I comfortable testifying to, and what do I need help with in terms of prices and markets and oil. Well, I'm comfortable with that as an energy economist. There may be strategic reasons to use other experts along the way in terms of
Geologists.
right, the technical reservoir expertise could be particularly helpful. And there are times where strategically you may want to separate experts' roles, and there could be strategic reasons to do that, including hours in the day and deadlines, some of that sort. So,
Yeah, I definitely agree. I mean, I guess I would add that, the economists will often be more comfortable dealing with prices or markets, right? So in this context, like projecting oil prices, not in every circumstance, depends on the specific product, but that's probably an area where the economists will be more comfortable. When you're talking about, assessing reserves, inputs, cost of production, and so forth, things that get more specific to the firm at the issue, then I think you're probably looking at a technical expert as a right fit.
And I think this is why I put the same question to our counsel. You're doing the case, you want to kind of quantify, and you say, I think we need more experts. And is this something that Julie suggested that it happens earlier in the case? You from the get-go start looking for those, or you start with the economists and then maybe in consultation you move on and expand the team? Or
Well, I mean, again, it depends, what kind of case it is. And although I have to say, as a general rule, you have your primary testifying experts on valuation. I think they're kind of what you start with. And they frequently will come to you and say, well, we can do this analysis, but it can be much more effectively done by, another more topic specific expert. And really this goes to kind of partly to strategy. Would it be beneficial having someone who could speak separately and more authoritatively, frankly, on a specific topic? And certainly, your testifying valuation expert will say, yeah, no, that would help. Admittedly, they can't be an expert in everything. And, like for instance, some cases you worked on, there was oil pricing and, futures and so forth. And that's a real specialty. And there's folks who do that day in, day out. And, something, an economist can look at and say something about, but when your case hinges on that specific issue, you'll probably want the best person in the world and the most authoritative person. And I think that kind of plays into kind of those choices. I think one thing I wanted to mention, and this is kind of, again, goes to more the lawyer's presentation advocacy of the case, is that if you bring in that specialized expert, do they have the testifying experience? Have they been before a court or other arbitrations? I mean, how do they present? Because frequently that kind of expert has no experience in a testifying environment. And that can be a concern because, even though you're getting them for their expertise, their written report, you do want them to be able to communicate effectively. And that's, a skill that doesn't frankly readily come to every expert in all these kind of very specialized fields. And the question for the lawyers then is this a project you want to take on? Kind of giving someone who's a newbie their first lessons and testifying. And it's not about, training them up as SEALs or, people who want to, do what you tell them. It's really about effective communication. And that just doesn't come naturally or easily to everyone. So it's kind of one of the considerations.
Thank you for kind of bringing it to this direction, the discussion, because I think that also goes to what you look into when you want to pick an expert. I think that's an early decision. It's a very important part of your case. You want to do it. And then, so you look for someone who has experience testifying and obviously is the subject matter, knows the subject matter well. And so those are very important aspects. Anything else you guys want to add?
I do, actually, there are a couple of things that I want to add. I'm trying to speak louder so that everybody can hear me also. On the issue of when you need a new technical expert or an additional expert, I agree with Julie. We always make an effort when we request a proposal from an expert before we engage them for them to do a case analysis and to indicate whether they think any other technical experts will be necessary. And then we ask for their referrals, because usually they know the area better than we do. So then we ask them to tell us who they recommend. So that it's very rare that it would become something that happens later in the case that you suddenly need a new expert. It's something we try to determine at the very beginning. I wanted to go back to the topic of what you share with the experts at the beginning, because I think it links importantly to their independence at the hearing and defending that at the hearing, because and their elaboration of their report, because usually they put in the report a section that says we relied on these documents or we were instructed on these points from the lawyers. So it's important, and those are usually the points about which they get attacked under cross-examination. So it's important to think about that when you're sharing information with them and when you're instructing them about legal issues. Will they be asked about this in cross-examination? You know, is this defensible, asking them to opine on this or telling them not to opine on this or giving them this instruction, or only giving them these documents so that their report doesn't actually review all of the necessary documents, that they could be at risk of something in cross-examination.
Thank you for expanding on that. Very useful. Now, I think we just get to the main topic. I have in my list of questions that how are you going to go drafting the damages section? And I think that's a question to our lawyer, and maybe you want to kind of start with that. You have kind of made the arrangement. You have your expert have done some kind of initial analysis. You're working with the expert back and forth. How do you go about that?
Well, we actually had a session earlier this week on kind of drafting the memorial. And so following up on our practical kind of approach, I mean, the memorial, at least from the claimant's perspective, is obviously, a critical document to get to the tribunal, to present the case, present the evidence, and present that first and main expert report or, expert reports. And, it assumes that you probably spent quite a bit of time working with your experts, going through the process of gathering documentation, making sure that the experts have everything they need. But it's a very, iterative process getting there and working with them. To some extent, people go off into their corners, do their work, but, drafts are reviewed and comments are made. And at the same time, you're still drafting, the award back section, the legal sections, however people divide that job up, but also the damages section, which then has to be coherent with the rest of it. So again, not an easy process, because as you know, these documents can be hundreds of pages long. But the idea, I guess, hopefully, is you've worked closely enough with your experts that it's not a last minute activity where you're kind of jamming in the expert report analysis into your, final section of your memorial, that you've been working as you go along to make sure that, the evidence as presented is consistent, that the experts have that the necessary evidence as you've gone along, and that by the time you get to the final kind of drafting stages, all of this is kind of be moving forward together. But it is incremental, and it is kind of a very, self-reinforcing process.
I have a question for you and then follow up for Courtney. I think one issue is that, is there some sort of a clear-cut rule or approach or kind of methodology on how much of the expert report you're going to put into the memorial? And I have seen a variety of approaches. I have seen they kind of repeat everything that the experts put there, and some kind of a counsel prefer just to put the conclusions of the expert. This is it. Go back and read the expert report. Is there?
Sure. I would say usually our damages sections are short, unless there are some particular special legal issues with the damages. And what we try to do usually is explain what the expert report says. And because it's often difficult to understand and they're often long, and we don't know that the tribunal members are going to read all of it, unfortunately. And so what we like to do is the damages section be a sort of layman's explanation of the conclusions of the expert report, and as much detail as that requires, as much technical detail as that requires. And I personally really like including sort of the summary charts from the damages reports, because those are the easiest to understand. They set out everything clearly. So we include that, and we'll quote sometimes, but not too much, because usually it's an explanation in layman's terms.
Thank you. Let me go to our experts right now. Maybe I ask Manuel this one. How do you prefer to work with the counsel? Now we ask them, they're kind of calling it as an iterative process, as an incremental process. What kind of a working rhythm or relationship or modus operandi you like to have?
No, I like that as well too. I mean, on our end, more communication better, generally speaking. We want to speak to counsel often, make sure everyone is aligned, knows what each side is working on, that there are no surprises at the end in terms of approaches.
Start with and progress forward. Is it started, like you're writing a paper, you agree on an outline with the counsel, etc. They instruct you on the legal things, like, okay, tell me your parameters of the law. And then
We usually would start with a conversation, and we usually would need additional information or some initial set of documents to come up with an outline. Like, that could be pretty short, tentative opinions, or kind of big sections of research, almost like a research agenda. Getting feedback on that, talking through that's really the way to get started, and then we just move from there. And the one thing I would like to add is also obviously there's the expert's independence, which is paramount in all this, but keep in mind that both me and Julie here, we also work with consulting companies, right? Usually I actually only work on the consulting side. So you can also take advantage of having a consulting team that knows the facts of the case and talk to you more freely than maybe what the expert can. And that can be helpful in some cases to, bounce off some ideas without necessarily putting those into the expert's mind.
Thank you. I think this is a kind of a good point where we kind of from there go towards hearings, preparations for the hearings. And there are a lot of issues. I guess there is one issue on the side of the counsel. How do you prepare for a hearing, or are the hearings useful at all? From your perspective, one of my partners in my old firm, he retired. He used to say that arbitration hearings are just kind of useless. You can't do anything. In litigation, we spend weeks. We go and work, and here you have 10 days to do everything. So now you tell me, are they useful or not?
I'll give my opinion on that, right? I'm actually surprised by that question, because I find the hearings the most useful.
There you go.
But maybe it's because I like visual, oral learning. I like seeing reactions, people. I like that, and I think that's how I digest information better. I mean, otherwise you just have your written briefs and reports, and that can get dry, and they can get very, very long. So I feel like the hearing is a great, efficient, because it's not usually that long, 2 weeks, 2-3 weeks, way to really drill down into what are the main issues before the tribunal and really what they need to decide. And usually I found in cases as counsel, especially writing the opening and closings and preparing for cross-examination, I understand even better than I did when writing the briefs what are the essential points. And I've even had moments of like epiphanies, like, if I put it this way now, then it all becomes clear. And it's something that is best communicated orally in front of the tribunal or through a Zoom. That's okay too. But I think hearings are great.
are great. Ian, do you think?
Yeah, I have to say, I don't really share your former partner's view, because I agree with Courtney. I mean, this is an
Okay.
advocacy opportunity for counsel, as well as for the experts to, people learn in different ways, as Courtney said, and the kind of that oral learning, as well as the ability to ask questions and clarify and so forth, I think is incredibly useful. I do believe, though, to your point and your partner's point, there are folks out there that don't have a lot of patience for the whole hearing, but in particular, the damages day, which is usually, at the end, and depending on, how many witnesses have gone over and your schedule, I mean, you could be cramming your, expert examination in the last 3 hours. And I've had that, situation where we extended through a Saturday, to try to get the experts in. And just a little anecdote, I was in one hearing where it was the last day and we were coming up the steps into the hearing, and I think I was with our damages expert, and there was a couple of arbitrators in front of us, and I don't think they saw us. One of the arbitrators says, "Yeah, it's the last day of the hearing. I hate the damages." And I think that kind of, fatigue of the coming up on the final day, I mean, that kind of is unfortunate because, obviously this is a critical part of a claim, and certainly from the defense point of view, that, you get a full airing and you have this opportunity to, present on both sides and have the opportunity for examination, which, plays a very, I think, useful role in the overall case.
Well, I have seen top arbitrators is sleeping during for a short period, just.
It's been a long week, right?
I'm tired. So, what about our experts? How do you go about preparations? Is it useful? You find this is a chance that I'm gonna defend my theories here, etc., or?
So they're incredibly useful.
You think?
And it's a wonderful opportunity to educate the tribunal. And that's the hat that I wear. I'll put on the professor hat, but you're having a dialogue, you're explaining, and you can immediately gauge body reaction. Do they understand or not? And so just like Courtney, it's always in advance of a hearing. I'm like, if I just explain it this way, this complicated math or industry aspect, that what's driving this, so that they'll understand and connect the dots. And real time, even if it's the last day at the end of a week, and I've rushed to the airport afterwards on Friday nights, being the last witness, still having the opportunity, despite my clear understanding, not everyone loves math like I do, and to be able to put it in terms that they can understand and context, and to be able to answer any questions. That's my job, and that's why I enjoy getting through the rest of the reports, but really, want to have the opportunity to make sure that the arbitrators best understand the circumstance in the case, and the evidence I'm giving for their benefit.
Manuel, any additional?
It's also a great opportunity to work with counsel to help them think through the key questions. Really, I mean, again, it's the last day, last few hours, key questions that need to be raised with regards to the other side's expert, and what it really boils down to, both from our direct case as well as from the cross.
I have a panel that all are in favor of having hearings. And now I'm going to ask you another question. Are the hearings long enough? Now, maybe my old partner was right. Now everybody is having a good time. Hearing is important. Maybe we should kind of prolong them. What do you think about that? Do you think you have enough time to kind of explain the issues in you said 2 weeks, 3 weeks hearing for a billion dollars, or you think a month would have been better?
That's a good question. That is a hard question to answer because for practical reasons, right? You're scheduling the hearing at the very beginning of the case when you're doing the procedural, and everybody, all of the arbitrator schedules, all of the counsel schedules, to find a chunk of time it's very difficult to find a chunk of time. 2 weeks usually is the maximum that you can find where everybody has availability. So I think there are practical constraints on the length of hearings. But I would say that I agree with Ian that often damages get the short end of the stick. They're always the last day, and we're almost always rushing, and we've eaten into their time. So if the cross-examination is down and really short, and it's all just in one day. So ideally, yes, we could do that more leisurely and have a few days for damages, but that's maybe more the fault of our planning and execution in the hearings than it is the decided length of the hearing. And I would also say for counsel, for writing closing statements, if you do closing statements, that can be very brutal if the hearing is short. And so for that reason, I would opt for slightly longer hearings, but again, I think practically it's not quite possible.
And I think part of the reaction to the kind of rush last day, you've seen the option of a tribunal to have a post-hearing process, and that may involve some element of the damages case. If there's issues outstanding that they may not fully understand or need a little bit more briefing, that is an opportunity. And I've seen a number of tribunals that I've worked with take that opportunity. So you might have a mini hearing or a month or two later, or some form of post-hearing brief. I mean, there's lots of options to kind of make up for the tight timeframes. I don't think I'd agree with lengthening the process. I mean, the process is already long. The submissions are long. The expenses are pretty high. So kind of looking to litigation as kind of the preferred world of let's have hearings for months. I think we're actually trying to move away from that in international arbitration. So I think it's really a question of just being more effective with the time we have. And that kind of circles back to your point about, preparation for the hearing. I think it's important to work with your experts to make sure that they are focusing on the issues the tribunal needs to hear. And one of those I find really useful is getting the sensitivity analysis. Having an understanding when your experts say, okay, you've got these 20 issues you're covering in your report. What is meaningful? What's material to the actual bottom line number? And it's usually like 2 or 3 factors, quite frankly. I mean, if it's a DCF, sometimes the beta is the big thing, or the country risk. And you just hone in on that, and you make sure that that's made as clear as possible. And that allows the tribunal, and from a tribunal's point of view, what do we need to focus on? And I think that kind of preparation in advance, I mean, I don't think it undermines the independence of the experts at all. It just helps focus what's going to aid the tribunal. And ultimately, that's the duty of an independent expert, is they're there to aid the tribunal.
Thank you. Let me ask a follow-up question right now. I think you mentioned an independent expert. And I think independence and credibility of experts are very important. And what is it that counsel do, or what is it that experts here prefer to just kind of preserve that in the eyes of the tribunal? And are there some safeguards that you need to take, protocols that you follow? Because after all, one question that I get from some client says, what are we going to do? We're going to pay these people or not pay? I said, nobody works for free. You got to pay them. I have had that question. It says, then are they going to be questioned? What if they charge a lot of money? So, I mean, these are professionals. They're charged, and the other side does the same. And so in their mind, that payment is associated with, of course, they're going to say something that we like. I mean, what are the issues there? How can you manage that process?
I would say actually it starts from the very beginning when we're choosing the experts. Again, when we ask for proposals from experts, not only do we ask for if you need other technical experts, we ask about conflicts. I mean, that's the very, very first thing we do is are there any conflicts? But then to go to independence, we ask about if they've ever worked even for our client before or related entities with our client. we ask if they've opined on these points before,
Mhm.
and if there's any, discrepancy in their opinions and those previous opinions, then we would think about maybe not choosing that expert. So it's something that is always, we try and protect from the very beginning, and it goes into selecting the right expert for the job. And then I think it shouldn't be very hard to defend, because the experts, yes, they get paid for their job, but they're experts. They're not going to change a sort of an answer, a right answer, because they got paid to provide it.
That's a very good. Our experts, any comment on that? Have you been put in a situation where, for example, a opposing party finds one of your opinions that happens to be available in the public domain and says, no, here you said that the discount rate has to include, for example, or not include country risk, and you're saying otherwise here.
So I've never faced those circumstances, and my entire approach to evaluating a case at the get-go is designed to protect me as an independent expert through the rest of my career, which is happy to turn down cases, happy to refer others that fit. I'm guarded for the long run of being an independent expert, because I think that's where I'm most helpful. But also it's how you're going to get retained in the future, if you're doing that job. So guarding yourself at the get-go is the key.
Manuel?
Yeah, I couldn't agree more. I mean, it's absolutely crucial, right? I mean, we would never put experts' credibility on the line. And as Julie said, maybe then the client has to think of a different expert, different approach, but that's a no-go.
I have one last question, I think, for the whole panel, and I think, or maybe for our experts, and then we open it for questions. I think that's a kind of from time to time, I'm sure you have been in the situation, or colleagues maybe have been that, or at least I have seen it in some cases where the tribunal is kind of torn apart. There's two reports, and they are way apart from each other. Well, they can go and, I don't know, hire their experts of own. It doesn't happen often. They just have to do something with the resources that are already available. So they order the expert prepare a joint report or try to kind of produce something like that. What would be your approach to that? Have you experienced that, issues that come? Is it useful, or they should go and hire an independent expert that might?
In theory, it could be productive.
In theory.
In theory, and where I've seen it, it has fallen apart. I don't know. I don't know if it's the nature of the individuals and the views or the case. I think sometimes perhaps an alternative approach is that separate experts hired just for the tribunal to help them understand and sort through that. That may be more feasible to make sure that they're understanding the differences. My concern is if there is a wide difference, that they understand the reasons for the difference. But alternative approaches, I think can be considered to some extent. Joint reports or hot tubbing, debating, have been tried, and those are at least trends that I've not seen escalate, suggesting great success, but others may have other views.
In the few instances I've seen it, basically the experts are just reiterating what they had said already in slightly different framing. So I have never seen it like actually effectively resolving or closing the gap. But I haven't seen it very so.
Yeah, I mean, in one of my first arbitrations, Martin Hunter actually was the chair of the tribunal, and he likes to think of himself as pretty literate from a math and arithmetic point of view. To put it mildly, I think he was an accountant before he was a lawyer. he actually, urged the experts to kind of get together to prepare a joint Excel spreadsheet with all of the variables. And so, it was an incredibly useful tool because they were at least able, and I think with some cajoling, to be able to kind of agree what the various elements of the analysis were and kind of put a toggle on them. Obviously, in that case, the respondent's expert was pretty much, toggled everything to the as low as possible, but at least the tribunal kind of had a range in which they could operate. This is the low end on this particular issue. This is the high end, and allow them to kind of go in a pretty systematic way through those issues. And then, interrogate the experts about, how they viewed each of those and why should I be on the low end or on the high end. And it just kind of made it a very orderly process. I do agree that that does not work in all circumstances because you're not going to get the experts to even agree on the premise that is the basis for their analysis. And that does happen. I mean, some experts come in and their remit is simply to criticize. They actually don't provide an alternative analysis. And that's more of a respondent kind of tactic. But, in some cases, you do have two experts that are talking the same language. Say a DCF analysis. I mean, DCF analysis has certain elements to it. You could disagree on many of it and the inputs, but at least the tribunal will have a sense of, okay, country risk, let's hear that. Let's go through the various elements. But it does, again, and this goes back to my first point, was it depends.
Yes, actually, I recently worked on a case where the tribunal ordered a joint damages model. And we did exactly as your other case, except that we had, the experts were so far apart that the toggle was for each of the levers, I guess, you could choose either the claimant's expert or respondent's expert. So there were 100 or so levers that you had to decide to switch a certain way. And it actually worked out very well. I mean, for us, it actually worked out well. And I think it was very helpful for the tribunal because they didn't have to do anything. They just picked what they wanted on the sheet, and the number that came out on the bottom, that was exactly what they awarded. And so for them, it was great. But I do think that as far as the tribunal hiring an independent expert, I've never seen that happen. And that sounds incredibly inefficient to me because just being, getting familiarized with the record would take so long and so much time. That just seems totally inefficient. But definitely the joint modeling I've seen. And although it was difficult at times to work with the opposing expert and opposing counsel, we came out with a product on the end that worked.
Thank you. I think that kind of sums up what we wanted to share with you. And then we are open now to questions. Please.
I want to piggyback on. Oh, I apologize. Sorry. Hi, I'm William Lowry. I want to piggyback on something that Ian just referenced at the end, which is instances where respondents put forward no alternative damages figure, and they basically just deny damages. I think that's always been with us. Like, that's a litigation tactic as old as time, but maybe it's just anecdotal. It's happening with disturbing regularity, even in cases where damages are very obvious. So, for instance, we recently had a bifurcated dispute where liability was established and the other side still refused to put in an alternative damage figure, which was shocking to me and seemed very high risk. I think what parties are counting on is that arbitrators will be reluctant to just find a measure of damages or exercise their authority to not require certainty in damages calculations and just say, this is the number more likely than not, and go with it. But I wonder how that phenomena affects anything that you've just said in terms of approach or strategy for drafting your damages sections of your memorials or your expert reports.
Well, it came out of my comment. I'll start. I agree. It's just something you see and you have to react to it. I mean, ultimately, if you're coming from the claimant's perspective, it's your case to make, and you're going to have someone trying to knock it down. So whether respondent actually presents their own number or not, it can be frankly inferred from the way they're knocking it down, and you can argue that. I actually, just another anecdote, I had a recent commercial case where in fact, it was the claimants who didn't put in a expert report and, specific arguments, and just relied on commercial information to support their damages claim, which, frankly, we did put in an expert. We were able to deal with that information, I thought, in a much more efficient manner. But you see all sorts of different strategies. I mean, it's really your imagination.
Yeah, I don't think that that's an effective strategy, because you're relying on the tribunal. The tribunal, as I think I've learned in cases where they ask for a joint damages model, they don't really want to do that work to figure out what the damages are. You're always, if you don't present something, you're at risk of them splitting the baby, which they usually do. So then you think, well, is half of whatever they're asking for, is that really what I want? You want to put forward a figure, even if that figure is zero, at least put it forward as saying that that's my, that's what we're saying is the damages amount. So just so there isn't that, just leaving it to the tribunal to do the work that they don't want to do.
Yeah, as a respondent counsel, which I do all the time, I would be worried not to put, if there is a robust claim has been put forward, I want to try to say something. It depends also on the tribunal, but there are some arbitrators that are very kind of a mechanical. There is an argument here, where is the response to it? There's no response. Oh, okay, you lose on this next one, etc. So it comes down. But then the other point also goes to the robustness of the kind of a claim and how well supported it is. If it's kind of based on evidence, etc. Definitely. But if maybe I think that okay, they haven't proven it enough, etc. You can take a risk, but it depends. I mean, I'm kind of more on the conservative. Okay, we're gonna answer it. Say something. Other questions, please, ma'am.
I was wondering if it's a good strategy to start working with the experts in the cooling off period, especially if the state will not settle the case. Would be a good strategy for the claimant to have the experts at least 6 months. Well, it depends on the treaty. That's true. But
No, it's a mystery for me. Sorry, I'm jumping in. I'm a moderator. I shouldn't be probably, but then I like always to use experts just to run the numbers and get a kind of a realistic view of these things. And I scratch my head from time to time when I get a request for arbitration, and I'm always on the respondent side. And they have put a very nice number with all the things, etc. So did they do it themselves? I mean, knowing myself, I'm a lawyer. I'm kind of pretty good with numbers, etc. But I would think I would need help to put this stuff together. And so I don't know. Maybe our experts can resolve the mystery if they can share some tidbits with us.
What lawyers do differently. I mean, I go back to that side of the table. I mean, I think we get requests sometimes and sometimes not.
Okay. Very early.
I've not studied the pattern.
I would think if you have if the client has the money to do it, then yes, earlier is better. Even in settlement negotiations, if you're trying to get, serious numbers and a serious settlement, it would be better to have an expert weigh in on what you're asking for, even in the settlement negotiations. So if you can, yeah, as we said, I think starting earlier, it's always good to have an expert as early as you can. It's practical to have one.
The arbitrators have any legal authorities to establish the method upon which the standards upon which you should avoid damages, because if you are using the wrong method to establish the damages, they are the ones who have to be responsible. So why should you even just start working at the beginning with your expert just to address what the other party responds for?
Might I repeat the question, because I think you're not going to be picked up by microphone where you're sitting. So, and to make sure that I got it right, the question is, if should the arbitrators say to the essentially experts or the parties what method of valuation they should use rather than leaving it on them? So
there should be some essentially ruling on that or some instruction on that. That's the question.
Yeah, I think most arbitrators would prefer not to be in the position of dictating kind of ultimately expert methodology, partly because there's so many different ways of coming at different valuations. Can be comparables, you can do DCF, you can do, sunk costs, and a lot of it depends partly on the legal case and how you want to approach that. So I don't know. I think as an arbitrator, I'd hesitate to want to be the person directing methodology. That being said, at the end of the day, in deliberations and assessment of the case, they're going to make that choice. And that'll come out in the award, but not necessarily kind of upfront, I don't think.
I agree. I think arbitrators generally defer to the expertise of the valuation experts, right? So the tribunal members usually aren't going to say, I know better than the valuation experts. They should use this method and not that method. I haven't seen that, and I wouldn't expect that to happen. And also, I think the tribunal doesn't want to do that work, essentially. But also, I think that often we present, if we're claimant or respondent, actually, you can present various methods of calculating your damages to give the tribunal that option. If you don't like this one is also valid, and here's what the number would be under this method. So strategically, we sometimes do offer more than one method of evaluating the damages.
That gentleman, you.
Yeah, so I had two questions really. One was
Repeat, please. Go on.
so I had two questions. The first one was, there's a trend sometimes for experts to actually rely on the testimony of fact witnesses, where the witness statements from the fact witnesses have come in first. And I'm wondering whether you have a view on whether or not that's a good thing, because sometimes your fact witness knows the business better than the expert. But then you run the risk of the fact witness being sort of destroyed in cross-examination and then the expert testimony following with it. So that's one question. And then the other question that I had is, very often I've seen, experts tend to also be asked to weigh in on interest and what is the relevant interest amount or the interest rate that should be charged in addition to damages. Now, that doesn't strictly fall within the experts' purview because they're supposed to be independent damages experts. But they oftentimes do, in fact, weigh in. Do you think that sort of affects the independence, given that that's not something that they're putting in their expert report, but might be advising on, informally? Would you have a view on whether or not that's good practice?
I think I asked the first question goes to our lawyers, and then the second one, I think it's both a lawyer aspect and an expert aspect. I tend to disagree with you, but let's see what our lawyers say.
I mean, on the fact witness part, there's certain parts of the evidence which are not supported in documents or independently. And as you say, the client tends to know their business. And if you get to that point and they're the ones that provide that evidence, then you really have no choice. Ideally, you want them to be supported by data and something verifiable and, preferably independent. To address, the scenario that you're painting, which is, if they are somehow impugned or, their testimony is viewed as unreliable, you don't want to be in a position that they're the absolutely last say-so on some strict, technical or, valuation related issue. So, yeah, no, I agree. That's a conundrum. But, this ultimately goes to how you use your witnesses as well. Witnesses aren't there to tell the whole case. That's for the memorial. They're there to, give you evidence on issues that they can reliably discuss. And you'd hope if you have, say, a senior person or say the CFO, and they were the direct person involved in a certain transaction, say, for instance, and have that background, then yeah, they'd be the appropriate person. But I do agree that there is always risk.
We have 1 minute. I turn to our experts to comment on the point on interest, the question on interest. Is this something yet you feel that you shouldn't be opining on, or
Or it depends, as our lawyers say.
So if I'm asked to give an economic opinion on it, I will give an economic opinion, but it's also often outside of my direction. And so it starts if there's with the lawyers and whether or not there's a guiding requirement in advance or view from that perspective. But if I'm asked to give an economic opinion, interest.
Just calculating it, for example.
Right.
That would be okay. Okay. Any reaction on the lawyers? Is there a side into this that you're missing? Or what I'm thinking sometimes, for example, the treaty may say it's a commercial rate or what is, but then the treaty doesn't say what does commercial rate mean? I mean, how are you going to go? You need an expert to go and tell you, and then what the commercial rate is, and that would require, you may look into a statute, some domestic law statutes, they have a specific rate in the statute. Okay, maybe that's a kind of a written as a lawyer thing you give to the expert. They just run the number for you if you can't do it yourself. I think this brings our session to an end. We thank you very much. Thank you everyone for listening. Please applause for the panel.